Welcome to the Sam and Joe VA Show, where we teach women just like you how to start and scale a thriving virtual assistant business.
We're your hosts, Sam and Joe, and get ready to have the control, flexibility, and freedom you've always dreamed of.
Welcome to episode 143, Navigating the Legal Bits in Your VA Business.
And we are so excited to welcome onto the podcast a senior lawyer from iCLAW, Simmi Singh. Simmi has a passion for commercial law and specialises in intellectual property rights. Welcome, Simmi.
Thanks, Sam. Thanks, Joe. Good to be on here.
Oh, we absolutely love that you are here to talk about a topic that we know it's kind of scary for some virtual assistants, and it can be daunting thinking about the legal aspect to your business. So having you on here to make it not so scary for virtual assistants and really talk through what they need to think about, what they need to have in place, I think is going to really calm the nerves of the virtual assistants.
Yeah. Because you're not intimidating at all.
Yeah.
You're a real person, and you want the VA community, especially the community here in New Zealand, to do really well. It's more than fine print and legal documents, isn't it?
100%. And hopefully most of the network have seen us being part of Sam's journey, from the get-go. So, yeah, we are real people. Don't bite most of the time. Happy to have a chat. And I've met some of you over the different networking events. So, yeah, I can assure you we are friendly people.
You are. Yeah, you guys have been friends of the VA network for, it must be over 7 years now. That's a long time.
That's a very, very long time.
Right, what are we going to start off with, Joe? Should we ease everybody into it? Contracts, I reckon. Like the legal contracts that all virtual assistants should be thinking about.
Yeah. What are the documents? What are the legal contracts that virtual assistants must have in their business, Simmi?
So that would depend on whether you're a sole trader or in partnership with someone else, and whether you have employees. So if you're a sole trader, the must-have is some terms and conditions, or contractor's agreement or service level agreement. Contractor's agreement is more broad, general scope, whereas service level, you know what you're offering on a constant basis, so that would be easy to articulate in that document. If you are in partnership with someone, we would recommend a shareholders agreement. That would govern the relationship between you. And if you have employees, a must-have is employment agreements. And for all of the above, an NDA, non-disclosure agreement, if you're trying to protect confidential information, is always handy to have as well.
And so should the non-disclosure agreement be with your employees, your contractors, or with your clients?
There's an obligation of confidence in most employment contexts, so that would be an employment agreement, but externally, so your clients, third-party contractors, subcontractors, everyone and anyone that you're working with apart from your employees, because they can be covered in the employment agreement.
Cool.
And what happens to me? I know there's a lot of, especially the aspiring virtual assistants that maybe don't have any clients under their belt. So, finances might be tight. They they look at the cost of a contract and go, oh, do I really need it right now? Can I get some clients under my belt first without having a contract and then start investing? Like, what are the downsides to that? What are the downsides to not having your first couple of clients sign a contract?
I think the biggest risk that we see is in regards to payment. So the basic terms is covering your payment, covering your bills basically. And if you don't have contract in place, you can't guarantee payment, or even and you can never guarantee payment, but enforcing payment. And your rights are definitely better protected if there's something written. If you are in a position where you cannot invest in contracts, I mean, you can start off with some of the templates that Sam has on the website and go from there. And you can use that for quite some time until you get a bespoke relationship where you can sort of get us involved. And if that is still not feasible, then at least have some terms in an email saying invoices will be paid within 7 days. There's always downsides, and people won't respond to emails, or there's always loopholes everywhere. So I highly recommend at least have even the template agreement, just to start off with.
At the very least, like we want everyone listening just to cover your bums, like in a legal sense.
Yeah. You don't want to be walking around naked. No one likes that.
No one wants to see that. No one wants to see that.
No. Yeah, cover your bums. I like that.
And so for you listening, if you are like, I need a template, we'll pop the website link to where you can purchase one of those down below.
I really want to talk about pushback. What happens? Because this does happen. You send out a client your contract, and it's robust. It's been put together by a legal professional. The purpose of it to cover your own butt. But sometimes you can get pushback. Now, it can be for a range of different reasons. We find that a lot of it is just the client just not understanding the legal terms. But there are other reasons why you might get some pushback. So for the virtual assistants that do get the pushback, what's your advice on that?
I mean, we used a lot of pushback. We get pushback all the time. We get it from our clients. We get it from everyone. So well-versed to answer that one, Sam. Well, I think you, as a VA, you should realise that you're the contractor, or you're the one that is offering a service, a very valuable service, and they need you. So it's better to dictate the terms that you're offering those services. And you can always use the services you offer and the fee or the consideration you're getting for your service as leverage. So if you're getting pushback on, let's say, IP and ownership of IP, we would suggest that you understand why. What is it that they want? Do they want to own it? If so, then maybe charge a higher fee for it. It's always beneficial for you to retain ownership in the work you create, because I would imagine you'd create advice that can be used for another client, and you want ownership rights in that, so that your hands aren't tied when you are faced with the same scenario later on. So it's asking the clarifying questions. It's asking, okay, what is it that you really want, and using that as leverage to get paid better.
Yes.
Asking them what their concerns are, like what would be your concerns that are coming to mind, so that you can really uncover what they're actually worried about. Because like you say, you could create this amazing template or an amazing calculator or a spreadsheet or something that's really cool that you've created for a client, but it's your knowledge, it's your IP that you could then use and have something for another client. So I totally agree that you need to be able to use what you have created in most cases.
Yeah, 100%. And we'll touch on, when we talk about copyright, there's this term that the product is produced with time, skill, labour and judgment. And if you've done that, you have copyright.
Oh, I can't wait till we talk about copyright. Oh, my goodness.
I'm sure you have some good stories.
Yeah. Going back to the contracts, though, Simmi, and another reasonably common request that some virtual assistants find from their clients is, especially, I guess, the larger, more corporate clients, not necessarily the smaller ones, the solopreneurs, or they've got very small teams, but the bigger organizations, they often have a contract that they want the virtual assistant to sign rather than them signing the virtual assistant's contract.
Yeah. And that's fair. It's David and Goliath, at the end of the day. It's very normal for big corporates to impose that. And in that scenario, I would highly suggest get legal advice, even if it's, hours with my time or anyone in the team. It's going to give you the reassurance you need to progress further. There's nothing wrong with, signing their contract, but they'll be heavily drafted, I can guarantee you, in their favour. So you'll have very little or control over that relationship. And it depends about what's your appetite for risk. And if you think, you know what, I've read it, I understand it, it's at your risk. If you just want a couple of hours of our time, or even an hour, we have to let you know the pitfalls, etc. So definitely think it's worth it. If it's a big corporate, there's always things that you think you understand, but we went to law school for that. So it may seem plain, but there's, I've seen the other side of it and how to turn better very quickly.
Yeah. I mean, I grew up, I don't know where I first heard it, but I grew up knowing never to sign anything, like any type of legal document, without getting legal eyes on that document. Like, I don't even know where that came from. So I'm like uber cautious. Like, I will send anything through to you guys, like just in case, because you just don't know what they've snuck in there.
Yeah. And it could be that, that clause right at the end or a sub-clause that you just skimmed past because, when you're tired and you're reading, you'll read you see what you want to see sometimes, and it's a bias. So whoever told you that, or wherever you learned from Sam, well done. Is there an opportunity for a VA, if they have been given a contract from a client, for them to negotiate on some of the clauses or get some edits and changes made to that so it is more in their favour, or they may not want to agree to something? Like, is it appropriate to negotiate on 100%, that? 100%. I think the common misconception is that once you get a contract, you think you just have to sign the dotted line, you take it or leave it. And that's not the practice anymore. You always negotiate a contract, always. That's just the rule of thumb. There can be something in there that can be inserted for your benefit. And the worst that can happen is they say no, but you'll never know until you ask. So definitely 100% recommend negotiating contracts.
Yeah, a virtual assistant might not want to negotiate because they think it's going to set their chances back of actually getting the contract agreed and, taking on that client for work. But I think it shows that you, I think they would respect you for wanting to negotiate that. It kind of lifts the credibility of you as a virtual 100%. Assistant if you're willing to do that. So don't be afraid of it.
It's like a new job, right? And it's like asking for a better offer. And if you can back that up, not negotiating a contract for the sake of it, but if you know your worth, you can back it up. Most people respect that, the confidence, and they're like, oh, wow, she values herself. Good on you. I want her. So it can actually work in your favour. Pushback is not always, I wouldn't even call it pushback. Negotiation is not a bad thing.
It's a normal part of business. It is an absolute normal part of business. You're going to be negotiating throughout your business career.
Yeah, life is a negotiation. Every part of it. I negotiate with my 1-year-old son, so
I was going to say, getting the kids out the door every morning. There's negotiation tactics happening there for sure. Okay, what's important to me? What can I let go? What's more important to them?
What's next? This leverage? Yeah. We know it.
All right. Is there anything else that you think our listeners should hear about contracts before we move on?
No, I think we've covered quite a wide range of it. And if you're ever unsure, as I've told both Sam and Joe, that feel free to reach out. There's a misconception that we charge for every conversation, but for us, what's important is relationship. And we do value the relationship that we've established throughout the network. So even if it's just a quick chat, that, hey, Simmi, and I've had those with some of you. What does this mean? And I'm happy to just have a conversation about it. And if you want to engage us for further review, to do that as well. So
Sometimes it's just about that feeling of empowerment, isn't it? That knowledge, that understanding that you give them. They then have the confidence to then go back and then do that negotiation, which is awesome. Yeah.
Exactly.
Oh. What do you want to get into now, Jo?
Yeah, let's go into copyright.
That little C symbol that you see around the show, what does that mean?
That just means that they are asserting ownership in their unique work. So, I mean, that's very broad, but copyright offers the widest protection of all IP rights. It's global. It can range from text to sounds to moving objects, 3D, even scientific works, formulas, creative content, templates, anything, really. And that's what most people rely on when they don't have any registered rights, which we can talk about next, like trademarks.
Yeah. So does this mean, I mean, like Jo and I, we put copyrights on some pretty important documents that go out into the world. Occasionally we put them on social media graphics that we know are going to get shared widely. Now what happens, because this happens to us all the time, what happens when that thing that you've put out into the world, that you've made sure you've got the little C on there as well, people still want to take that, make it their own, kind of, but not really. So it's basically copying.
Change the colours.
Change the colours. Okay. Yeah, let's be honest. They might change the colours, and then they're putting it out into the world without kind of acknowledging the person that they actually got it from.
Yeah, so copyright protects the expression of ideas rather than the idea itself. Unless it's like the first car that was ever invented. You can't have copyright on a car, for example, but it's an expression of, let's say, Tesla. You know, the way it's all these different components are put together, they have copyright in that, all the different components. And copyright grants moral rights to the author. So every time that work is reproduced, or if a Tesla-looking vehicle comes up on an ad, they've got the moral rights to be acknowledged that that's theirs. Same with your work that you put online. You're letting people know that there's copyright in this, that I want to be acknowledged, that this is our work. And if people are using it without your permission or acknowledgement, then there's potential infringement. So, yeah, fun stuff.
Can anyone, so to copyright your work, can anyone just put the C in the circle logo on the bottom of their document or on their social media graphics? Like, can anyone do that and use it?
Anyone can do that, and everyone does it willy-nilly, but that, the test for enforcement is a greater beast to tackle. Whether it actually has copyright is a different question, whether it is unique and novel, and there's a legal test for determining whether copyright does exist. But to answer your question, Jo, yes, anyone can just chuck it on their work, but there's a different question when it comes to enforceability.
What if you haven't put that little symbol on your work and somebody's copied it? Can you still then enforce it? Yeah, it doesn't. You don't have to. In other words, you don't have to put that little C on every single bit of piece of work that you put out there.
100%. Yeah.
Okay. Cool. All right. Should we talk about enforcing? Like, at what point?
Because this comes up in the VA industry a lot, where especially websites, I find websites and social media. Graphics is the kind of two common areas that we see. So, someone creates a website and then someone else creates a website, someone new coming into the industry, and they've clearly looked at that website, copied and taken over the text, the whole kind of look of the website. Someone has seen that. Like, what then can happen?
There's lots of things happening there. Is that
there's lots of things going on.
Lots of things happening for that person. Apart from being lazy. And copyright is interesting because it goes really well alongside fair trading claims and passing off or using someone else's goodwill, basically. And that becomes crucial when you're trying to enforce infringement, is that you would reach out to that person and saying, hey, you actually are misleading and deceiving the public because this sort of looks like my brand or my what I offer on my copyright or on my website. And if it's likely to deceive and confuse the public, the stronger your claim would be. And it's better to stop that, as Sam would know, as quick as possible. The faster you get on it, the better it is. And you could be on the receiving end too, that, you know, you searched for different VA websites and you're like, oh, that looks cool. My Girl Friday is a really cool brand. Maybe I could springboard off that. But, you know, it's always good to do your research and spend enough time, as I touched on earlier. If you spend enough time, skill and labour, and that could include contracting out to developers or etc., incurring costs to actually develop something, greater the protection is. So I would definitely be calling out people that are trying to use your work.
Yeah. I mean, this kind of goes into that discussion that we've had on a few times, Joe, around you also need to be aware of the energy that you're putting into that. Like, and Simmi, you and I have had conversations like this multiple times, and we're going to go into my trademark saga, as I like to call it, very, very soon. But, you know, even in terms of just that copyright side of things, it's like, okay, how that energy that you're going to be putting into shoulder tapping every single person that's doing it, could that be somewhere else? Could you be putting that same amount of energy and time and focus somewhere else that's actually going to be bringing in income to your business? It's a balance, isn't it? It's a balance, but we totally get it. Having experienced it before, both Joe and myself, it really hurt. Like the emotions that come up in you when you see your work being copied. Like, I don't think you can just ignore that. Like, you need to do something in terms of being able to let that go somehow. And whether or not that is as simple as you say, Simmi, is just reaching out to them on a VA to VA level and saying, hey, did you know that, you know, about copyright?
Looks the same.
Yeah, did you know that we've got that? You've copied it word for word. And I've done that once. I remember once I contacted you guys and you're like, hey, just flick them an email or pick up the phone. Honestly, just do it. I'm like, oh my God, that just seems really confrontational and I'm not very confrontational. How's that going to be received on their part? Am I going to be made out to be the bad guy? But I tell you what, one email, it was done. They acknowledged it. They had an excuse for it, of course. They didn't completely own up to it. But they then took it down. They took it down. So I was like, oh, wow, okay. That was just an email. And it made me feel so much better. I felt as though I was more in control of that. I wasn't just being this doormat, allowing it to happen time and time again. But you don't always need to be getting a lawyer to do it, for doing that kind of that low end touch, right? That first touch.
100%. And we always recommend to our clients to try that first because it's a practical solution rather than incurring a couple of grand for us to write a letter. And most times it works, but infringement is another thing because you actually have to show loss to the court if you do want to take it to court. What does it actually cost you? And you have to be able to prove that because you can't just simply say they've copied it. Sue them. It doesn't work like that. What is the end result? Can you show that you've lost 10 clients because of that? If you can't, it's going to be like, see you later. What are you doing here? So, it's important, as you've mentioned, Sam, to really weigh out the costs and not always be so litigious about it, but always asserting boundaries and your rights. And you can do that with just an email initially. And then later you can just passively start setting me in and then, you get results otherwise. Yeah.
Do, which we're going to talk about as well. But I think you need to weigh up the cost of it and the benefits, and what you've obviously been triggered. Like if you were having such a emotional response to something like this, like there's something else going on. It's triggered something in your past in terms of not being appreciated, or maybe you've been copied in the past and it hasn't been a very good experience. Like, also take a look at that side of things, I reckon. Because I get triggered by this all the time, so I need to deep dive into why.
I want to always say it's a compliment. People copy good things. It's a compliment.
It's a compliment.
Obviously, you're doing something right.
I hate that quote, Simmi. That copying is the sincerest form of flattery. I call bullshit on that. Like, no.
All right, so we have a chat about trademarks, because this is different to copyright, isn't it? So how is it different, Simmi?
So trademark can be registered or unregistered. It's specifically for words, letters, symbols, sounds, tastes and smells. The smell of KFC and the taste, secret recipe.
Wow.
Logos.
Yep, logos, colours, pictures, three-dimensional objects. So, visual as well as sounds and smells. It is territorial, so it's not global. So for it to warrant protection, you have to register it in the country that you're seeking protection. It must be distinctive and dissimilar to anything that's already registered or out there. And again, it can't be deceiving or misleading or contrary to public order and morality. Sounds so fancy. And it offers you exclusive protection for 10 years, and you can renew it indefinitely. Steps involved to get anything trademarked would be to do research first, do a feasibility test as to the uniqueness of the mark. Anyone can jump on the iPhone's website and do a search for name or slogan. You can even copy paste, the VA show and see if anything similar has been registered or someone has tried. Yeah, so lots of ways to do the feasibility test, and then you determine the type of protection you're seeking, whether you want the way the brand looks, the pink with this font, or do you just want the word, the Sam and Joe VA show. And then you just file. Anyone can file. You don't necessarily need a lawyer to. But yeah, you contact iPhones and they'll be very happy to help. You can also have unregistered trademarks. So how you identify that is that if someone has a brand and they have the TM symbol at the end, and that's how you identify that they're trying to assert rights but they haven't registered.
So can anyone just write TM?
Yeah, if it's not registered.
And then it changes to R, doesn't it? Once you've got the final okay and this will come through. Yeah.
Yes, Sam, you got it. Yeah.
So sorry, you go, Jo.
So so if I had a TM, what is kind of the extra protection that I would get if it was registered?
So the TM basically not indicates definitely that you haven't done all your feasibility tests to get it registered. It's not as enforceable and straightforward if you've registered it, because iPhones go through the exercise of seeing if there's anything similar to that before they register your mark. So when you register, it shows that extra step, and it's easy to enforce, because if it's unregistered, then there's different considerations. Who's at the market first? Who's established their goodwill and reputation in that market? So the enforcement is a little bit trickier. And the cost of actually filing a trademark isn't very much if you do it yourself through iPhones. I don't know the exact cost, but it's a lot cheaper than trying to enforce it later on through lawyers. Thank you.
Yeah, it's relatively easy to do it yourself. It is one of those things. There's certain things, if you are doing it yourself, you need to be aware of. Like I remember when I did mine initially, and it was kind of like, well, I didn't really future-proof it because I'm only kind of trademarking my current services, not necessarily the services I may want to offer later on. So really thinking about not only your business today, but your business and how that's going to look in the future as well. Joe and I, we've both trademarked our respective virtual assistant businesses. When would you advise a virtual assistant business owner to consider it? Like, should all virtual assistant business owners be considering it? I mean, we've got them, but that doesn't necessarily mean to say everyone should have one, right?
Yeah, exactly. I mean, I would recommend that you consider it from the get-go. Start fresh. Do your research. As mentioned earlier, you don't want to be on the other side of receiving a lawyer's letter saying, "Hey, this is actually very similar to our client's brand." So I would consider all IP protection and how that's all framed, even in your terms of engagement from the get-go, and registering your rights as soon as possible. And, before you spend money into marketing and branding, you don't want to get caught in the backfoot later on.
So at least doing the name, is that what you mean?
Yeah.
At least
at least doing the name.
So you want to be confident that the name that you are registering is going to be your name for a decent amount of time.
Yeah, you don't want to spend 5 years in business, have this, full of clientele, and just to know that yours is very similar to someone who's been around for 10 years.
Yeah.
And then suddenly you are having to provide a narrative to existing clients while you're rebranding.
Yeah.
And we've had that before. So you don't want to establish goodwill in something that you haven't protected from the get-go.
What added protection, if any, do you get with a trademark that you wouldn't naturally get with the copyright laws? Like, for those VAs that are going, well, it sounds pretty similar. Like, if I just use the C on everything, what's the difference? Like, the effort that I'm then going into getting a trademark, what are the benefits?
The trademark benefit is, it's copyright's global, and it protects products and templates, whereas trademark is focused on the name, the brand, and the look and feel of the brand. So, yeah, you could most infringement cases always have a fallback on copyright.
Okay.
In our experiences, but intellectual property is multifaceted, and you need to consider it from all angles. And it may be an easy fallback to rely on copyright, but that is usually granted for the work you produce. The formula is the template. You can't register templates, so the difference would be to focus on the name, the business, the brand.
Gotcha. Yeah,
and that would be the benefit of the trademark.
So if you are really wanting to protect your brand, then
trademark is the way to go.
Trademark is definitely the way to go. Yeah,
and you can renew it indefinitely. Whereas copyright protection lapses lifetime plus 50 years of the author, whereas trademarks is indefinite renewal. Ownership of it forever. And then, if you, there's a famous case of Windows and Apple, where I think Bill Gates was one of the first to look at one of the iOS systems that Apple produced. And it's a very interesting case. If you have time, do jump on and read it. And it shows the importance of registering your ownership, and then that goes into patents and software development, etc., on your inventions. But after a while, now everything after the 50 years, people will start to copy things that existed, like the first car, or the light bulb. After a while, it enters the public domain because that's what creates the betterment of a product, a novel product, and then you have different variations of smartphones. But whereas trademark is particularly focused on the brand, and I'm pretty sure Apple will be trademarked for life.
Surely.
It'll keep getting renewed, right? But the look and feel of the iPhone, and let's say another, God knows how many years, components of it, it's still being copied now anyway. But components of it will enter the public sphere where people can start using and reproducing it. So,
yeah.
Right. Let's go into your saga, as you called it.
Saga, the trademark saga. Well, I guess my biggest learning from having a trademark and then protecting that trademark would be that having a trademark and protecting that trademark are two totally different things. And Simmi, this is how we got to know each other really, really well, going years back when you were instrumental in protecting that trademark for me, because I had no idea. You mentioned that, actually getting that trademark is relatively cheap.
Yeah.
But you've got to then be prepared to put some money into protecting it.
Yeah. And you did. And we got
I did.
At the end. Yeah.
But you know what? I could have put a lot more money into that had you not been the type of lawyer that you are, and the iCLAW wasn't the type of firm that you guys are. You could have, because Mark and I were like, let's do this. Let's take it
to court.
We're ready. Let's do it. And so you literally had to pull us back from the cliff. And you're like, oh, I don't know about that. There's some, you really need to think about this. And this is why, because it will drag. It's not going to be an overnight thing, and you need to think about the money involved.
Yeah, exactly. But I'm glad that you did invest initial resources to protect the brand, because then people took you seriously. Because there wasn't one, there wasn't two, I believe there was three.
Yeah, there were three.
Trying to use your brand as a springboard and drive off the goodwill that you had established.
Yeah.
But we got involved, and I'm glad we did, because we did get a good result.
We got an excellent result. I couldn't have asked for a better result in terms of all three. And for anybody, I think for me, it was important to protect the brand because My Girl Friday has a really strong brand. It was a stronger brand 7 years ago than it is now, because I've got other things that my attention goes to. But back then, very strong brand, coming up on Google when anyone was to search on page one, which is huge. If you're turning up on page one when someone's searching for a virtual assistant in New Zealand, and you've done all that work in terms of creating a strong brand and being seen on page one, for others, like you say, to then springboard off that causes confusion in the market, doesn't it? Yeah. And that's what you are protecting from. It's more than ego. There's a little bit of ego involved, but you've got to put that aside. If there is confusion with people searching for My Girl Friday, and there are multiple My Girl Fridays then coming up, well, then I can absolutely show that there's a loss of income there.
Yeah. And it would be different if the brand was My Girl Cakes, or even if the argument could have been weakened if it was My Girl Friday who was into baking, or who had a shop somewhere solely focused in a different industry. Then the argument is much weaker.
Yes.
Unless the brand, the look and feel, and the logo, the font, the colours were identical, then we have a problem still. But if it's in a different industry, to Joe blog, it doesn't cause confusion, then that's
because I think there was at the time. I think there was, and we were just like, no, there's just no point. There's no point even going there. And even I was like, nah, there's no confusion. Like, I don't care if a florist is called My Girl Friday. Yeah, what do I care about that? But it was the other virtual assistants that were doing some online research and obviously came up, that's a cool name. Wow, that's a neat brand. I'm now going to copy it. So we dealt with these three in different ways, didn't we, Simmi?
Yeah, we sure did.
Do we want to talk about it, like the different kind of strategies?
Yeah, happy to talk about it without disclosing too much detail.
Yeah.
A few of them were put on notice to close or change the branding on their social media. We tried bringing a few.
You did, yes.
Yeah,
yes.
We tried bringing a few. I was a pest. I kept bringing because she wouldn't reply to my emails. I even sent her a LinkedIn message because she just ghosted me. But being pesty works, as lawyers would know.
You were persistent. Yeah.
Yeah, we were persistent, and that showed that we were serious. And it was funny because I think one of the virtual assistants had immediate family members that were in the legal fraternity. So it was very surprising that, and she was the one I think that was the most difficult because she kept kicking the ball, kicking the can down the road, and be like, "Oh yeah, I didn't know." But if you're assertive in protecting your rights in any way, it could be emails, messages, calling them. I think we were even tempted to do like a mystery shopper kind of call as well. And I'm not sure whether it was with you, Sam. Maybe a client did tell you, because how did you come aware of this?
Yes, it was a client. I think a lead. I think someone had recommended me to somebody, so they'd gone, I'm going to Google her and see what comes up. Yeah. And then realize that there were a few. And so then when I did get on a Zoom, for a consultation, they were like, did you know that there's a couple that come up? And I was like, no, I did not. Oh, shit. Okay. Because I had done all of my due diligence when I first started out my business. And I set up my branding and all the rest. I made sure that I had checked the trademark registered. I'd Googled everything. I'd made sure that no one else was coming up officially as My Girl Friday, because I didn't want to be that person either.
Yeah, exactly. And we wrote letters for all of them. Some responded straight away. Some didn't. But that's always our first point of contact, is to let someone notice that you are infringing our client's trademark, and then just persisting from there on in.
Yeah, because I'm in the situation now where, Strictly Savvy, I've had the brand for 10 years. It's trademarked, but it's trademarked in New Zealand. So there is a virtual assistant that I saw pop up maybe a year ago as Strictly Savvy in Canada. And so I thought of you, Sam, and your story, and I was like, okay, how much energy do I want to put into this? So I contacted my trademark lawyer and I said, what are my rights? This has happened. And she pretty much said, trademarks are in the country. So if you wanted to, you could trademark something and, you'd have to set up over in Canada, or at least, I can't remember if it was like have a website or something that shows a presence in Canada to be able to then say and get a trademark and then say, hey, you can't use that brand name. And I was like, you know what? I'm just going to focus on Strictly Savvy in New Zealand and not worry about that. focus energy on, like you say, Sam, bringing income in and doing a really great job for your own business. This just wasn't worth it.
It's really interesting. And I think that will surprise some virtual assistants to know that the fact that it isn't global, especially when a lot of us have global clients. Like, we don't necessarily specifically say we only work for New Zealand clients. We have clients around the globe that for one way or the other have found us. So despite having a global clientele, I guess, you would still need some type of official presence in that country. Is that right?
Yeah.
Yeah.
Yeah. I mean,
interesting.
Your presence is by offering services. But if your target market is New Zealand, and you would have to establish enough goodwill in Canada, or be just have a reputation in Canada for you to be able to register that mark anyway.
Yeah,
so interesting. And this is why we're not lawyers and we get proper legal advice, right?
Absolutely. All right, so before we wrap up, let's touch on just a couple of other key things that we've seen come up in the industry, Simmi, that we'd love your view on. So one thing is, we see some virtual assistants going into business together. I went into business with a partner back when I first started my VA business. And so what would be your advice to anyone considering that? What do they need to think about?
Lots of things. To start off with, how is your relationship going to be governed? And you may be friends now. This is difficult to say, but you may not be in 20 years, And it's always good to future-proof. And future-proofing doesn't mean you don't trust your business partner, but it's to have sufficient mechanisms for exit if, your goals change or you don't want to do it anymore. So that's very important. The first thing is, how is your relationship going to be governed? What are you bringing to the table? Are you going to be equal partners who are, if it's an even number of shareholding, how are you going to resolve a deadlock? Are you going to have an independent chairperson, or are you going to have 3 directors? How will you be remunerated? Will you be a shareholder employee? Mechanisms for exit is probably the crucial thing. So I think if you're going to business with someone, also thinking about employees and having employees, and just having the right framework as to the relationship and future-proofing it, always future-proofing the relationship, and allowing either one of you or multiple of you to exit when needed. For example, offering the other shareholder preemptive rights, so buying the shares or being offered the shares first before the other one exits and offers their shares to someone else. And having enough checks and balances to prevent the other shareholder just bringing in someone without your consent or without the board approval or etc. So I think you have to be very careful and seeing as the glass half empty, I suppose. And seeing what are the risks and exposure and just protecting the relationship.
Because Joe, in your case, it didn't end well. Did you have those contracts and agreements and stuff in place? Had you had those conversations with your business partner?
We had some conversations, and we had a draft document. We never had anything signed. So, we just had to make it up and figure out what we were going to do and have really tough conversations. So, definitely, if you are starting a business with another virtual assistant and creating a virtual assistant business together, have something written and signed, have these conversations, because it's kind of hard, isn't it? Because you're talking about what would happen if the business or relationship ended when you're just trying to get it started and you're so excited about starting this new business. Nobody wants to talk about what would happen if one wanted to stop the business, right? But it's so important. So is that a shareholders agreement? Is that the document that would need to get signed?
Okay.
Yeah.
It's like a prenup for a business, right? It's a prenup.
I know.
Yeah.
This is mine, this is yours.
And something else that I hadn't considered until we started sitting down and writing up this agreement is what would happen if someone was, say, in a really bad accident and they were in a coma. They hadn't died, but they were unable to communicate and work for an extended period of time. What happens? Because that could be an indefinite, like, who knows what's going to happen. So those kind of conversations need to happen as well, which are scary and weird and awkward and unusual. Because, what do you do?
Yeah. How much easier had that draft actually been a proper contract, Jo, would the dissolving that relationship have been?
Right. It would have been way less stressful, way less emotional, and just a little more black and white.
Yeah.
That's what we hear.
And I think we're going to see, I feel like we're going to see more and more partnerships coming up like that in the VA space as well. I think sharing that load emotionally and the actual workload, the client workload, or if, you're really good at something, but you're not very good at something else, and then you buddy up with a VA that's really good at the stuff that you're not good at, I think we're going to see them more and more.
Yeah. And there's multiple ways to structure ownership as well that we can help with. There can be a limited partnership, there can be a company, it can be a joint venture where you are a relationship with two separate companies coming together to do something. There's multiple ways to structure ownership, especially if you're have multiple assets. It's also very important to have a chat with your accountant or lawyer how to structure your business quite separate to your family home, etc., and protecting your family as well. So,
My biggest advice would be to go into it only if you're going to get professional advice, because there are all sorts of tax implications and risks involved if you don't do it right. So absolutely. If you're going to do it, you have to be committed to doing it with professional advice so you get the structure right. Otherwise, it could cause a whole lot of issues down the track.
Yeah.
All right. So lastly, this is something that has come up recently in the VA industry, and that is about buying and selling a virtual assistant business or a virtual assistant clientele only and not the brand. So let's talk a little bit about how does someone go about selling or buying or selling part of or just selling or buying clients?
Or even how do you make the decision as to whether or not there is any value in your business to sell?
Yeah, exactly. So selling customer lists only is a little bit uncommon. It's more common in a sort of merger and acquisition sort of scenario where one person comes in and subsumes the intangible assets like the customer list, but still wants their brand because they've established more goodwill and it has a better reputation. So when one wants to sell customer lists, there's a few questions that are to be asked, like why they're doing that and why do they want to separate the brand from it, because customer loyalties are largely associated with the brand. And there's no guarantee that if you buy the customer list that they will stick around, because you're a totally different person, totally different brand. The locality, the relationship could be totally different. So interesting that that's come up, because it's not very common. You'd either have a share sale where someone just sells shares in their company, or have a asset sale, which is take everything.
You can't underestimate the value of a strong brand, especially in the type of space that we're in here, where that know, like, and trust, that trust is massive in a VA and client relationship, because you are accessing some pretty, some stuff that your client wants to be really, really secure
Mm-hmm.
Yeah, and it's hard to separate the customer list from the goodwill, because customer list, branding, IP are all encompassing of the goodwill. And how do you quantify that? I mean, unless it's a regular stream of clients providing the income and supply contracts. Like supply contracts are easily can be signed or sold because, you know, there's a guaranteed ongoing relationship. But a list of clients, you can't force clients to still be in relationship with the next person. So,
I mean, if I was a client and my virtual assistant was like, love working with you, but I've decided to move in a different direction. I'm going to sell the business. This is the virtual assistant that I'm going to sell it to. I'd be like, well, hold on. How do I know that they're any good? Like,
that's
how do
right.
I know we're going to get on with them? This is just, this is a stranger to me.
Yeah, exactly. And there's some ways to, I guess, cover that. You can have a probation period to hand over those relationships and see whether, you know, the vendor might be just wanting to try whether it still works, whether it's, you know, valued at X, whether it does deserve value at X, and have enough time to maybe secure those clients before they're actually on board.
Yeah, because often in those contracts where clients are having to move over to another business, there's like a retention kind of payment, isn't there? So they pay for the clients as long as they stay after a certain amount of time. And if they leave before, then they don't need to pay for those clients, that kind of agreement. So I think there's a lot of different ways that it can be structured, right? But again, really important to get some legal advice so that you do it properly.
Because you also don't want to undervalue your business. Neither do you want to think that you're going to get tens of thousands of dollars for this business when in actual fact I don't think so.
Yeah, exactly. It's about what you bring to the table and really considering why the reasons you want to purchase, and separate the brand. Is the brand not doing so well? Is the brand quite personal? To you and your family. So really asking questions about why would you want to separate the brand from the client list. There's obviously something, a personal reason, or the brand's it's not doing so well.
Yeah. So it's assuming a virtual assistant's got a great brand. They want to step away from the VA space altogether, so they're happy to sell the complete package. What would be their first step? Would it be coming to iCLAW and getting advice, or would it be figuring out the value of their business first?
I would probably go see an accountant first, get a dollar value for, or get some recommendation as to how that can be valued and the implications of doing so from assets and tax perspective, and then coming to see us as to how the agreement can be drawn up, or the intention behind. Talk through the intention, and sometimes just talking through some of these questions, you come to the conclusion, actually, maybe this is not such a good idea, because you know, all my 3 clients, they're big clients, but they've told me from the get-go that they don't want anyone else.
Yeah. All things to think about. I've seen virtual assistants that have sold their businesses on a very casual basis, like they've had no accountants involved in terms of value. They haven't had any legal advice. There's no contracts set up between the seller and the buyer. And then they've then come into issues whereas, I was supposed to get the client list and I haven't, or they've locked me out of their social media accounts and I haven't got access to those either. So another reason, this is where the legal side comes in, right? Like if there was a contract in place that you both sign, then that's really clear. Well, of course, they've got to provide those things.
Yeah. And another important consideration would be non-compete, right? You're buying someone's business. You don't want them to go set up shop down the road. I mean, in your guys' scenario, it won't be literally that, but you know what I mean? So that's a very important consideration. It's about non-compete and
Oh, lots to think about there, Simmi, and thank you so much for coming on the podcast and making it a little less daunting and really showing that, you know, you're there to help you can have a complimentary conversation with you to just run something past you or figure out what the next steps are, or even get an estimate of what something might cost, which we're really grateful for. So thank you very much for offering that to everyone listening.
Yeah, and if you're listening and you're a member of the VA Network of New Zealand, remember iCLAW are one of our awesome business partners, so you can get a discount every time that you do need to pay for their services. And if you've listened to that contract conversation that we had right at the beginning, you're like, oh damn, I need one of those, check out the VA Network of New Zealand's website as well, and you can get them direct from there. That's Simmi and the other wonderful lawyers at iCLAW have put together specifically for New Zealand virtual assistants. Thanks, Simmi. You're brilliant.
Oh, thanks, Anne. Thanks, Jo. Thanks for having me on here, guys. It's been a pleasure. It's always lovely to see your pretty faces and talk about all the fun stuff. As you both have said, reach out. We can go for a coffee, talk about things, and we're always here to help network and support the business as much as we can.
Thanks for listening to this episode of the Sam and Jo VA Show. If you'd like to find out more, head to the VA Foundry website to check out the Members Club and the amazing resources, training and coaching.
You can find us at thevafoundry.com.